Good morning. The reservation policy, the roster system is concerned, and time to time doors of courts are being knocked. Multi number of star mark judgments, Indra Sani, so many cases are there. See, actually, when I was working at Nagpur is a reserved constituency. So when selections were made, they only selected candidates from SC/STs, their reservation quota only, even though the other candidates are on merit in the panel. So that I challenged, being a union leader. That went up to Supreme Court. What my claim was subsequently upheld. So similarly, this case, AR 2026, Supreme Court 463, Airport Authority of India and others, Sham Krishna B and others, Constitution of India. See, the most important ratio is recruitment, irregularities. Recruitment in question arose from 2013 advertisement for 245 posts of junior assistant fire service, comprising 122 unreserved, 78 OBC, 22 SC, 23 ST. After completion of selection of process, only 158 candidates were appointed. All 122 unreserved posts were filled on merit, while only 10 OBC, 22 SC and 4 ST candidates were appointed. Appellant authority prepared merit list by first selecting candidates for unreserved posts purely on merits, including reserved category candidates who had not availed any relaxation, and all scored marks equal to or higher than unreserved candidates. Such candidates were treated as selected against unreserved post. Respondent, those qualified, scored less than last selected unreserved candidate and was therefore placed in waiting panel, not selected. High Court held that roster had been wrongly applied and directed appointment of respondent and compliance with 1997 DOPT Office Memorandum. High Court misunderstood purpose of reservation roster, which operates after selection and is meant to regulate cadre strength and future vacancies, not to govern selection process. Reserve category candidates selected on their own merit can be adjusted against unreserved post. Since all 122 unreserved posts were filled strictly on merit and without any relaxation, selection was valid. Order of High Court upholding irregularity in recruitment process was set aside. See, the most important things, some points I would like to brought to your important notice. They say DOPT scheme as implemented in the memorandum dated 23/1/2000 provides simplified format for maintaining reservation register, and the authority has followed that format. The authority's maintenance of reservation register in the prescribed format and its method of preparing UR and OM list conform to the administration issued on the subject. Then this is what then they say Rajasthan High Court versus another. So many cases were discussed at paragraph 32 to understand the proposition of law. They say that the open category is not a quota, but rather available to all women and men alike. Then what about migration? The term migration was dictionary meaning is to one place to another place, shifting. But here in the reservation public migration refers to candidate claiming benefit or entitlement. The word is used as at least two scenarios. Interstate reservation migration, that is totally different. You may be classified as SC in one state, but you may apply in another state where that community may not be SC. That is also migration. Scenario 2 is there is merit inducted shift. Although the shift is largely referred to a migration, we find Saurav Yadav case explaining the term adjustment of reserved category in the unreserved category based on his merit. See, these things are there. I will come to an important aspect. They have set aside the division bench judgment and said what the department authority has done is very good uphold. Problem was, if suppose you are being selected unreserved candidate on merit without claiming any relaxation, because SC/ST people will have relaxation of age and marks in qualified degrees. Here what had happened, if you are selected in the unreserved category, your promotion will be next and you can be eligible. But if you are being selected in another category, then that will be a problem. Indra Sahni case deals with such a that see that the 50% of the reservation may not exceed. All these things are there. I hope you understand the judgment. Go through the judgment. It will help for students, public aspiring, public prosecutors, everybody. You have to go through the judgment. This is by Justice M.M. Sundaresh and Satish Chandra Sharma. Best wishes.